Welcome once again to Lehto's Law. Here's Steve Lehto.
We've talked before about how in America, a jury comes back and either finds you guilty or not guilty. And the fact that they've called you not guilty does not mean you're innocent. It just means that the case against you is not proven. However, there is a concept at the law called actual innocence, and it pops up from time to time, but it's usually way down the road after you've run out of all your other possible appeals. And so Darren sent me notes and said, Steve, check this out. Fascinating article. Baltimore man wins writ of actual innocence. Actual innocence in 1991 murder. Now, Madeline O'Neill wrote this, an eyewitness who recanted his testimony, and police interviews that were never turned over to the defense helped a Baltimore man win a writ of actual innocence in a 1991 murder for which he served 25 years in prison. And so the court's saying not only does he deserve a new trial, which can be based on technical issues or mistakes or whatever, the court's saying we find that this guy's actually innocent. Now, there is a slight hitch there, but I'll get there. A city judge granted the writ and ordered a new trial for the man, who is now 60 years old, but the Baltimore City State's Attorney's Office subsequently dropped the case against the man last month, although it did not support the petition for the writ of actual innocence. The petitioner has produced significant evidence that he is wrongfully identified as the perpetrator, and further, that he affirmatively was not the perpetrator, the judge wrote in his opinion. Hall presented several pieces of newly discovered evidence of his innocence, which is required for a writ of actual innocence. Among them were several exculpatory police interviews that were never turned over to the defense for Hall's original trial in 1992. So imagine this. You go on trial. They bring all kinds of evidence. A jury convicts you. You go through the appellate process and you exhaust all your appeals. And then someone comes up and goes, oh, by the way, we've got this thing that proves you're innocent. Believe it or not, there are some places where they say, well, you can't file any more appeals because you've already filed all your appeals. Now, newly discovered evidence sometimes can do it, but you've got to prove there's some reason that you didn't find it earlier, and et cetera, et cetera. However, the courts have always said as a last-ditch effort, if you can actually prove you're innocent, which is an extremely difficult thing to prove, if you can prove you are innocent, well, then we'll take a look at it, because it would be wrong to have somebody locked up in jail, especially for life, if they actually can prove they were innocent. So I've seen this argument come up before. A key eyewitness also recanted his testimony and claimed that he only identified Hall as the shooter under pressure from police detectives. Police accused Hall of fatally shooting a man on Bryce Street on the night of July 13th, 1991. At trial, prosecutors presented evidence from two eyewitnesses who identified Hall as the shooter, but there was no physical evidence tying Hall to the killing. One of the witnesses has since died, said she caught a glimpse of the shooter when he knocked down one of her children while he ran past. Another eyewitness also said he had seen Hall holding a gun. The two statements appeared to corroborate each other, and Hall was convicted of second-degree murder and using the gun in the commission of a felony. He was sentenced to 50 years in prison and could have been paroled after 25 years. Defense lawyers for Hall did not know, however, that one of the witnesses had told police several times that he did not see the shooting and only identified Hall after being interviewed 4 times. At a hearing on Hall's petition in March, that man testified he repeatedly told officers he had not witnessed the shooting and only arrived a few minutes later. A few weeks later, Patterson said, police pushed him to identify Hall as the shooter and suggested that the witness could escape drug charges if he cooperated. We need for you to put these initials on these statements or you're going to go to jail for drugs, he said, the officers told him. I was sitting there high as a kite. They said, just initial this. So he says that he was high and he was not telling the truth. The defendant had representation from the Mid-Atlantic Innocence Project, which investigated the case and uncovered the new evidence. The organization's executive director said Patterson's testimony, that's the witness there, shows a pattern in which police officers disregarded truthful information from witnesses, and then prosecutors failed to turn over exculpatory information to defense lawyers. The files got to go to the defendant. They got to know about the interviews, whether or not they helped the prosecution. So you had a flawed investigation, and that flawed investigation was reinforced by the failure to make sure the defense could expose that flawed investigation at trial. Spokesperson for the Baltimore Police Department could not immediately be reached for comment. Another witness to the shooting said definitively that he knew Hall and that Hall was not the shooter. Another gave descriptions that did not match Hall. None of those statements were provided to Hall's defense, according to a petition that he filed for a writ of actual innocence. At the March hearing, a city prosecutor agreed that a jury would have discounted Patterson's testimony given the new information discovered by these lawyers. The state's attorney's office did not concede in Hall's petition, though it dropped the case against him for insufficient evidence last month. So there's all the evidence pointing to his innocence, and they admit they haven't got evidence to convict him, but we still won't support that writ. Hall was represented by Margaret Abernathy of the Mid-Atlantic Innocence Project, Rayan Watson of Kramer 11, Naftalis, and Franklin, and Barry Pollock, a lawyer at Harris, Laurent, and Wexler, LLP. While the court's recognition of Anthony's innocence comes 3 decades too late, it is gratifying that the world now knows that he was innocent all along. And so I've seen cases before where somebody goes to trial on relatively thin evidence, but they get a conviction. Guy gets convicted, runs out of all of his appeals. All kinds of Innocence Project people are looking at it, and they're going along, and they've exhausted all the appeals. They've run out of everything, and then something comes forward, and, oh, by the way, we can prove you're innocent. And I've seen it before where courts on appeal have said, well, you've exhausted your appeals. We're sorry about that, but, rules are rules. And so I think most people agree that underlying our legal system and the law books behind me, the blue ones, and our court rules that govern how things happen in court and how appeals are handled, that underpinning all of that is if you could actually look at somebody and know they were innocent, they shouldn't be locked up. Doesn't matter if the system spoke or the jury spoke, or if we knew. Now, I understand people say, but Steve, there's no way to ever know. Sometimes, maybe not, but sometimes there is. And I've seen it before where I've actually seen a court write, we know that this man looks innocent, but the jury found him guilty. Juries make mistakes. All kinds of people make mistakes. Courts make mistakes. Judges make mistakes. Appellate courts make mistakes. And so if somebody is actually innocent, I believe they should be let out. Obviously, to determine actual innocence is an extremely high bar, and I admit that. And so that's why you don't hear about these cases that often. You do not hear about them that often because of that. But once in a while, it happens. So that's one of the stranger things that happens in our legal system, I think, is the way that the appellate process, each time you go up, it seems to get narrower and harder, narrower and harder. But once in a while, you'll see somebody who goes through trial, court of appeals, state Supreme Court, federal court, writ of habeas corpus, and then Court of Appeals federal, and then Supreme Court, and boom, it gets reversed. And you go, wait a second. All these lower courts made mistakes. Yeah, that happens. I've seen it happen before. And I've mentioned before, one of these days I'll do a video on it. A guy I know whose father was convicted of murder at one of the worst trials. I actually watched part of the trial. I actually went and attended part of the trial. It was one of the worst trials I've ever watched. And his father was convicted of murder and went through the appellate process in the state of Michigan and just got shot down everywhere and filed a writ of habeas corpus in the federal system. And the first judge to looked at it and goes, oh my gosh, you can't have a trial like this, and spun it around. And so it happens. It happens. And sometimes it's political. Sometimes it's the climate. And so by that I mean the political climate. And so those things can happen. But here the guy, it appears, was convicted on very thin evidence, and I'm being very nice when I call it that, and a writ of actual innocence, where a court actually said, based on what I've got in front of me, this guy appears to be innocent. Therefore, I'm going to release him from jail. Now, they could have retried him, they say, because the actual innocence is simply saying, based on the evidence in front of us, he appears to be innocent. Presumably, if they came up with all kinds of new evidence that no one knew about, they could have tried him again. But what would they have found after 25 years? So it does seem like a conundrum at that point. So the man's getting out. Baltimore man wins a writ of actual innocence in 1990 when Murder Madeline O'Neill wrote that, and Darren sent it. Thanks a lot. Questions or comments? Put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. A problem is a chance for you to do your best and not have to relearn the lesson.